Good morning and welcome to an oral argument session in the 5th District Court of Appeal. Let me begin by introducing the panel. As you've already heard, I'm Judge Palmer. To my right is Judge Sawaya. To my left, we're happy to have an associate judge with us today. Judge Rouse from the 7th Circuit has joined us for the session today. All of the cases on the docket today are civil cases. Each side will have 20 minutes. The appellant can reserve as much of their time for rebuttal as they like. There's a clock, and we'll try and help you if you tell us how much you want to save for rebuttal. Please make sure if you've got any cell phones that they're turned off. The first case on the docket is State Farm versus CURRAN.
May it please the Court, Elizabeth Russo on behalf of Appellant State Farm Mutual Automobile Insurance Company. I'd like to reserve 5 minutes for rebuttal, if I may. And subject to any questions that the Court may have, we would like to rest on our briefing as to the new trial points. Our focus on this appeal is our contention that summary judgment should have been granted against the plaintiff. The plaintiff was suing under an insurance contract with State Farm, but didn't comply with a condition precedent set by the policy. Specifically, the policy provides that any person making an uninsured motorist coverage, a claim under uninsured motorist coverage, shall be examined by physicians chosen and paid by us as often as we reasonably may require. And then the condition section of the policy provides, under suit against us, that there is no right of action against us until all the terms of this policy have been met.
Is there a difference between a condition precedent to filing suit and a condition precedent to obtaining ultimate recovery and obtaining damages? Is there a difference?
I don't know whether there would be a difference. I think, well, this was made a condition precedent to filing any action.
All right, if that's the case, then, and let's assume that it's a condition precedent that was not complied with, then what's the remedy?
Then there's no entitlement to benefits under the policy.
What would have happened if, I understand that the suit was filed and then eventually sometime after that, the exam took place. Is that correct?
Eventually.
All right. And do you know how long after suit was filed before the examination took place?
I don't know precisely. I know it was a matter of at least months.
Okay, months. But sometime after the suit was filed, she was examined. And so I assume that there was some meeting of the minds as to the examination, who would be present, who wouldn't, and the conditions on the examination. Is that basically correct?
Well, there was arguments back and forth, which were ultimately resolved by the court entering an order that set certain conditions.
What would have happened if, after the examination took place, the plaintiff had voluntarily dismissed the suit and then refiled it? Would the condition precedent to filing suit had occurred?
No, it would not. If the policy was breached and the condition was not met when the plaintiff went ahead and filed suit to begin with, the point of the provision of having an examination is so that the insurer can make some evaluation of what should be paid. Whether there's a condition that was caused by the accident.
I thought that perhaps you may have conceded that it's a condition precedent to filing suit, which means that you can't file a lawsuit against us until the condition precedent has been met. Well, the lawsuit was filed, then the examination took place, and my question to you is, if that's the case, what would have happened had they dismissed the suit and then refiled it after the examination, and you had the time to do your evaluation? Then what?
Well, no, I still think that, and certainly under the case law, the De Ferrari case that was adopted by this court in the Kazuri case, it is a condition precedent, and if you file suit without having complied with it, then you are not entitled to the policy benefits, and summary judgment gets entered against you.
Do you know if there's a difference between a condition precedent to filing suit and a condition precedent that just completely bars recovery?
Well, I'm sorry that I'm struggling with that question.
What I'm getting at is the remedy. If it's, and I think there is a difference between a condition preceding the filing suit, which simply says you can't sue us. That doesn't necessarily mean that, that recovery is barred unless the procedural aspect of complying with the condition preceding is met, as opposed to a condition preceding that says if you don't meet this, then you're just totally out, then the contract is voided and you got nothing to begin with. And it seems to me that if there is a difference between those two, that there may be a difference in the remedies involved in the event the condition preceding is not complied with. That's what I'm asking you.
Okay, and well, then in that case, I don't think there is a difference. I think that the policy is saying we will not pay unless you submit to the conditions precedent that we have set, and the reason is so that they can evaluate what happened. I mean, this case is a good example. The accident took place in June of 2006, and it was, nothing further was heard after some initial PIP payments. Nothing further was heard for a year. And then came a demand based on a claim that the plaintiff has RSD, reflex sympathetic dystrophy, for the entire $100,000 policy limits. So the insurer has provided itself a contract right to examine the plaintiff or the claimant to see.
Yeah, I understand all that. Let me ask one other question. The examination was ultimately taken, and I think it was Dr. Urici, if I'm pronouncing the name correct. Isn't that right?
Uricchio. I'm sorry that I haven't heard it pronounced.
But in any event, the examination was taken. You had listed him as a potential witness, but you never called him at trial, did you?
No.
Does that have any bearing on the breach of the condition preceding and what the remedy should be?
No, I don't think it does. I mean, the Fourth District addressed this in the Goldman case, which involved an examination under oath, but where they were looking at, can we now, at this point, say?
I think they said you don't really have to establish prejudice, but if there is a difference between a condition preceding the filing suit and a condition preceding that just completely bars recovery, that would make a difference. That factor would make a difference in terms of us saying, well, maybe it was just a de minimis breach, and therefore. Perhaps the remedy would be no cost, no bad faith action, something like that.
Well, no. I mean, it is a condition. I mean, it's the policy's provision, and that was the agreement between the parties, and it was breached. They had the opportunity to comply, and they breached.
The policy says you have to comply with all conditions, and one of the conditions is you can't sue us. You can't file a suit unless all conditions preceding have been met. One of the conditions is the examination, right? All right. Just wanted to make sure. Was
the examination that was ultimately conducted pursuant to the provision of the policy, or was it pursuant to the IME provisions of the Rules of Civil Procedure?
It was pursuant to the IME provisions of the Rule of Civil Procedure, plus some conditions that the judge added on. The plaintiffs continued to ask for a bunch of their conditions, and some of them the trial judge, and some of them would be more appropriate in the context of litigation.
Do you understand his question? Do you understand his question? His question was, did you request this examination under the rule or under the provisions of the policy? And you said you requested it under the rule.
Oh, not originally.
No.
Maybe I misunderstood.
My question was, once you got into the lawsuit, when you ultimately got an examination, did it require you to rely on the IME provisions before you could get your examination, or did you get it just because of the policy provision?
It was. Well, we were in litigation then, so it was based on the Rules of Civil Procedure governing such examinations.
You had a civil remedy notice at the time, and then the insurer asked for this exam pre-suit?
Yes.
So there were time constraints, and you had to evaluate the case, or perhaps have other remedies could be sought against the insurance company. Well, let me ask you another question, if I could, about reasonableness. The only contract restriction that talks about reasonableness here is the number of examinations, right? It says as frequently as we may reasonably require. So it goes to how many?
Yes, as often as we may reasonably require, exactly.
Reasonably require, but it doesn't say reasonable specifically about anything else, does it?
No.
So you could have scheduled this exam in, you, the insurance company, in Anchorage?
Well, I think that the law probably implies into every contract some good faith obligations to not.
Okay, you've anticipated my next question, and that was going to be, both parties to a contract are going to be held to act reasonably in fulfilling the contract. Is that correct? And whether it says reasonable or not?
Yes, I think that's true.
Okay.
But I think that the conditions that were being imposed, or that the plaintiff was imposing when we asked for the examination prior to suit, as we were entitled to, there were at least some of them that were not reasonable, some of them that would interfere with the way a doctor would conduct an examination, for one, and another one was just a flat statement that State Farm had to agree that no further examinations be required of Ms. Curran should this matter proceed to litigation or otherwise. The policy itself said we could have as many examinations as, or examinations as often as we may reasonably require, but also the plaintiff herself had neurologist, she had pain specialist, she had other than just RSD people. So if we got to litigation.
Are you conceding that the courts should look at this condition preceding and say that, yes, there are certain requirements that the other side can ask for that would be based on a test of reasonableness, and if they're reasonable, then they can be engrafted on as a condition to the examination, and if they're unreasonable, then they're not? Basically conceding that we should apply some sort of reasonableness test to examine whether the demands made by the opposite side were appropriate or not?
No, I think the policy provision is clear and that it requires compliance with the policy provision, period. And that's what we're relying on the DeFerrari case and this court in adopting it. That's the end. But if the court were to say, well, we want to look at it from the point of view of whether these conditions the plaintiff were requesting was reasonable, I'm saying that this case, that's not going to help the plaintiffs in this case because they had a completely unreasonable
But the
demand.
trial court, what do we do with the trial court finding that they were reasonable? I mean, the trial court had a hearing, examined all this, and said, I find that they're not unreasonable, that they are reasonable.
He said most of them. He didn't think that this condition about never being able to have another examination ever in litigation, before litigation, or otherwise, direct breach of the contract, direct breach of the anticipated breach of the rules of civil procedure. He said, I don't think they could do that, but I think the rest were reasonable. And what he said was, I don't think there was a meeting of the minds on all of these conditions.
But what do we do with the finding that at least the majority of them were reasonable? Do we just discard that, or what do we do with that?
I think that's irrelevant. I think that was the wrong legal analysis. I don't think it has anything to do with anything. I think he had a policy provision. He had the law that says if there's not compliance with this, then summary judgment should be granted against the plaintiff, and that's what should have happened.
Ms. Russo, could I ask you, what is an insured to do, say, on the 24th examination request, or if the exam is scheduled in Anchorage, to use my rather far-fetched example? Is there anything an insured could do to test the reasonableness, or do they have to say, I'm not going to go to Anchorage for the exam and risk, based on your reading of the law, giving up my entire right to recover, or I'm going to have to fly to Anchorage? Is there anything they could do short of one of those two choices, or different than those two?
I think that they could certainly suggest whatever alternatives they wanted, and if they could bring a deck action and let a court determine for them that question, but not just bring the lawsuit and say I'm suing for the UM benefits, never mind your policy conditions.
Wouldn't the standard potentially be not reasonableness but good faith? Because in a contract action, arguably you could say the implied covenant of good faith fits into the contract, right? And so that if they showed something was in bad faith, maybe that would be a basis on which to...
I think that's the better analysis, because the law does imply duties of good faith for all parties to a contract, to all contracts. The reasonableness is really a different
Are you
consideration.
withdrawing your
So
concession?
I think Anchorage,
Are you withdrawing your concession that
I
it
guess
should
I
be
am.
reasonable on both
Yes,
sides?
I am. I think it should be analyzed under a good faith analysis because that's implied in every contract. And requiring someone to go to
What's the difference between good faith and reasonable?
well, I just know that the law implies the duty of good faith.
Well, is there a difference between someone acting in good faith and someone acting reasonable under the law? If it's reasonable, does that mean that it could possibly be in bad faith?
Well, the law is developed as far as it has. Good faith is what's implied in contracts. Reasonableness is really more of a tort concept. And
Well, we're talking about a tort here, aren't we? We're talking about the commission of a tort because in UM coverage, the insurance carrier takes the place of the tortfeasor, and the basis of the recovery is a tort that may be covered under the policy, and recovery of damages based on that.
no, I don't think on the straight contract issues as to whether the insured complied with the contract conditions. That's different. The tortfeasor part of when you're trying the motor vehicle accident, I think that's where the tort aspects come in.
I think I would agree with you on that point, that when you're talking about whether there is coverage or not, that's strictly a contractual undertaking in terms of whether the insurance contract provided coverage. But ultimately, what you're doing is trying tort issues here to determine whether there's an entitlement to recovery under the contract.
Well, tort in the sense of who was using reasonable care in driving their motor vehicles, but
can you tell me if there is a difference between good faith and reasonableness in terms of the issue that we're talking about here? Did they act in good faith in putting forth these conditions to the examination? And is there a difference between good faith and reasonable? The trial court found that most of them were reasonable. Would that mean that some of them, that they may have been acting in bad faith, even though the trial court found they were reasonable?
Well, as to one of the conditions, and it was, that State Farm had to agree that there would never ever be any other examinations conducted, even though the contract entitled State Farm to that and the rules of procedure entitled State Farm to that, to say, I will not come to this exam unless you agree to something, to never have any other exams. That's
What did you think about
well outside the contract.
What did you think about the condition that the physician had to answer under oath interrogatories, the non-party physician? Was that, in your mind, a reasonable?
I think that's also what it's doing is modifying the contract. It's proposing to modify the contract, and we didn't agree to modify the contract, and so you go to the contract as written.
You have about 2.5 minutes if you want to save it for rebuttal.
Okay, thank you.
One more thing. May it please the court, I am Marjorie Gadarian Graham from Palm Beach Gardens. With me is John Alpazar, and David Alpazar is sitting behind him. They were trial counsel. I would like to begin by addressing some of the questions that the court has asked and then arguing with regard to the first issue.
In light of the language of the policy, did your client have any right to condition an examination on limiting the examination to one time?
Possibly not, and I think that Judge
Why wouldn't
Jacobus-
that then be dispositive of the case? If they didn't have the right to impose that condition, regardless of whether other conditions were reasonable, why wouldn't that be dispositive?
But the point is that that was never addressed by the insurance carrier. As I recall, all of the conditions that we asked, what State Farm addressed was the request for a videographer for attendance of counsel, and I believe one other issue. But a number of the things, for instance, our request that a report be provided by Dr. Uricchio, that's in the policy.
Now, it wasn't a request, was it? Wasn't it a demand that your client would not submit unless these things occurred? That doesn't sound like a request to me.
I don't know that you would characterize it that she would not request, but what Judge Jacobus said was the parties never had a meeting of mind about certain things that Judge Palmer are not addressed in the policy. And bearing in mind, this is a contract of adhesion. It's drafted by the insurance carrier. It does not address a number of things. And for instance, in the DeFerrari case, one of the things that the court addressed there or stated there is that the requested IME, which was under a provision, was in no way unreasonable in terms of location, frequency, or type of examination requested. Now, I would submit to the court that that language indicates that there are reasonableness issues that can be addressed in a request for a physical examination under a policy.
Wouldn't the appropriate means to address those issues be to either file a deck action or file some sort of proceeding to get the trial court to say, yes, this is appropriate and this isn't, rather than simply making demands as you did in this particular case and saying, well, the demands weren't met, we're just going to go ahead and file suit?
Except for one thing, Judge Sawaya. I hope I've pronounced your name correctly. Under their interpretation of the policy, which provides, and I've got the exact provision here, on volume 2 of the record, page 328, the provisions titled Suit Against Us is changed to read, there is no right of action against us until all the terms have been met, and then they go on and set forth things. Under that provision, you could not even bring a deck action. And more specifically, I do want to address a question that you raised to Ms. Russo, and that is, what is the appropriate remedy when there's an alleged failure to comply with a condition precedent? And Rule 1.120 of the Civil Rules addresses pleading of conditions precedent. I think the closest example of what you do when a condition precedent is not satisfied is, for instance, a case brought under the sovereign immunity statute, or, for instance, a case brought by someone who purports to be the personal representative of an estate. If the condition precedent, for instance,
you're talking about a policy provision that says there is no right of action against us unless condition precedents are met, isn't that basically referring to right of actions to recover under the policy as opposed to a deck action to say, well, what are my rights under the policy? There's a difference between a deck action that just declares, well, you may have this right and this right, as opposed to a cause of action to actually recover under the policy. Is there a difference there? And isn't that what that clause is referring to?
I'm not sure I understand your question.
Well, you brought up the point that, my question to you was, well, wouldn't it have been appropriate for you to file some sort of a deck action to ask the court, Judge, these are the conditions that we think are reasonable. We should only have one exam or two exams, and, this doctor being 1,000 miles away or 100 miles away is unreasonable, and these are the conditions that we want attached to the examination. are these conditions appropriate or aren't they? And I said, wouldn't it be appropriate for you to file a deck action? And you said no, because the policy provision says there is no right of action against us unless the condition preceding is met.
That's correct.
My question to you is, isn't there a difference between a deck action that simply declares what rights may be and a cause of action that actually entitles you to recover? And isn't that clause the latter rather than the former?
I'm not sure I understand that last part, but yes, to answer your question, there's a difference between a deck action and a suit to collect benefits. However, if you look at the literal language of this policy, which is found on page 328 and 329, it says you cannot bring any suit against us. But more importantly, Judge Sawaya, if that procedure were to...
But what happens if there's coverage dispute? I mean, you're saying that, in order to determine whether there's coverage in a deck action potentially being filed, you have to undergo an examination as a condition preceding to the policy first? Even to determine whether there's coverage in the first place?
Under the argument that State Farm is advancing, I would say yes, because, and let me backtrack a little bit, they not only argued that, as they do here on appeal, failure to satisfy a condition precedent, but if you review the transcript of the hearing on the motion for summary judgment and their actual motion, it was a mixed argument that, number one, there was a breach of contract by the insured, and, as they argue here, failure to satisfy a condition precedent. Have I answered your question?
I mean, I'm still, not really, because it seems to me that the appropriate procedural mechanism for you to use to get a determination as to whether your demands were appropriate or not was to file some sort of an action with the trial court to say, Judge, this is what we want, we're stuck, what does this contract mean in terms of what are the requirements that we can impose on this examination? A deck action, I think, would have been appropriate and a good way for you to do it rather than filing suit and facing a potential, breach of contract claim for failing to comply with that condition preceding. I think there are better ways for you to have gotten that before the court. And I'm not sure that clause that you quoted to me prevents you from doing that.
I was wondering if, go ahead, I'm sorry.
Oh, no. Perhaps I can answer both.
Assuming, for the purposes of argument, that all of the insured's proposals and proposed conditions in this matter were perfectly reasonable. Putting aside for a moment the adhesion contract and what might come out of that, but in an ordinary contract, is there any principle of contract law that requires the other party to agree to perfectly reasonable proposals to modify, or is the contracting party free to say, while your proposals may be very reasonable, I don't choose to modify?
Are you suggesting the insurance carrier or the insured?
Either one. In this case, it would be the insurance company. The insured has proposed or demanded all kinds of modifications, additions, things that aren't written there anyway, as conditions to attending an examination. They're not in the policy.
And that's the distinction, because it is not a modification of the policy. What the insured asked for was things that aren't addressed in any way.
Well, let me follow up on that then and give you this hypothetical. What if the only thing your client said was, I will submit to the medical examination conditioned on your agreement that you will not examine me again? That was addressed in the contract, correct? Because the policy specifically says as many times as reasonable. If that was the only condition that your client placed on the examination and the insurance company said, no, we won't agree to that condition, could you have gone ahead and filed suit and proceeded with this action, or would you be out of luck because you didn't comply with the terms of the policy?
I think that would that ultimately, in my view, goes to good faith issues, which, and this goes back to a question.
Is that a yes or a no? Could you have proceeded to, or would you have been out of luck?
I think we could have proceeded, but, and this goes to the first question that Judge Sawaya asked, which is, what is the appropriate remedy if you fail to satisfy a condition precedent? The appropriate remedy, in my view, is you dismiss it and give them leave to satisfy the condition precedent.
So your client could have simply said, I'm not submitting to a medical exam unless a judge orders me to do it, and go ahead and file the lawsuit anyway. And they would have been perfectly able to proceed, and if the judge ordered them to do it, then they'd have to do it, but it wouldn't have precluded them from going to court. Is that your position?
It depends on whether there is an allegation that we failed to satisfy a condition precedent, or whether the allegation is that we breached the contract. In this case, we had both issues set forth as affirmative defenses, both things argued as a basis of the motion for summary judgment.
So a plaintiff could, in every instance, say, I'm not going to give an examination unless a judge orders me to do so, and the only remedy is they go ahead and file suit, and ultimately the judge orders them to give the exam, and they say, okay, now I'll give the exam.
No, I do not think so.
Why not?
Because that goes back to the right to bring the action if the insurance carrier says you haven't satisfied a condition precedent, therefore we are moving to dismiss the lawsuit. That, in my view, is the appropriate remedy. It's not to issue a summary judgment for the insurance carrier, as State Farm contends should have been done here, where you have a policy.
If they were entitled to get a motion to dismiss granted, couldn't they just as easily get it at the summary judgment stage?
There is a totally different purpose for the two. And I go back again to the example of failure to give notice under the sovereign immunity statute. You cannot sue a sovereign if you haven't satisfied that condition, I call it a condition precedent of the statute of giving notice. That's what ought to happen when you say there is no satisfaction of the condition precedent to bringing suit. And
Did your client ever ask the court, Judge, please just abate the action, we'll go back, have the exam under their conditions, and then come back and start up the lawsuit again? That wasn't the way this happened, right?
No.
You asked for summary judgment, and now you're complaining it shouldn't have been resolved on summary judgment?
I am not complaining of that. I am suggesting that what State Farm should have done was, if it thought, in fact, this were a condition precedent, which it didn't, it took a mixed approach on the case. It took the approach we flatly breached the contract as opposed to condition precedent. Now, in this appeal, it's stressing condition precedent and saying that essentially, as a matter of law, if you don't satisfy a condition precedent for bringing suit, then we get a summary judgment against you. And it goes back again to the very first question that Judge Sawaya asked, which is, what is the appropriate remedy? Now,
so you're saying because they, on the very first opportunity to respond to this lawsuit, they filed an affirmative defense, raised it themselves. Did you raise that you had complied with all conditions preceding? Was that stated? I don't remember. But in any event, whether you did or didn't, in the complaint, in their answer, they raised, what was number 24 or something, affirmative defense. They said you didn't comply with the condition precedent. And you're saying they shouldn't have done that. They should have filed a motion to abate the case that was on, the ball was in their court to do it?
Abate or dismiss until the condition precedent is satisfied. And may I?
Do you have any case law that indicates that's the only remedy or that's the appropriate remedy?
I don't have a specific case in terms of a UM policy demand. I can tell you, I mean, I know that there are cases dealing with sovereign immunity. And I would also point out to the court that conditions precedent can be waived or a party can be stopped from asserting them. And Judge Rouse, I want to make sure one issue is clearly understood, and that is you said we moved for summary judgment. State Farm is the one who initially moved for summary judgment against us on all liability on its part. We then filed a cross motion for summary judgment. Another issue I want to address.
But I'm sorry to interrupt, but you could have filed, it's not just State Farm that could have filed a motion to abate. You could have voluntarily dismissed, gone back and said, we'll do your exam as a condition, or you could have, I suppose, asked the judge to abate the action while you went and had the exam because upon reflection you realized you weren't entitled to set a condition that this would be the only exam.
Except, and I believe that last issue, it was either addressed by Judge Jacobus at the hearing on the motion or in the order, and he expressed some concern about whether one could do that. But bearing in mind both parties stipulated at the hearing on the motion for summary judgment and cross motion that there was no dispute about the facts. Judge Jacobus then went through the things that the plaintiff asked to have happen and found that they were not unreasonable.
Is that a conclusion of law or is that an issue of fact?
Well, when the parties both say that there is no dispute about the facts, I would say under those circumstances, it's a conclusion of law.
Which means our review of it would be de novo because we're in as good a position as the trial judge in deciding whether they are reasonable or not.
That is correct. And on a summary judgment, we both agree it is de novo. I want to address one other issue that Judge Rouse, you have raised. You mentioned the 624-155 notice. Please remember that the initial demand for policy limits was made in July 19th. The 624-155 notice was served, I believe, August 21, so that State Farm had until sometime, I think it was October 20th, to respond. It had a total of 90 days of time. There was no rush, as it somehow suggests in its brief, to get things done.
Well, there was a time constraint. The clock was ticking. They needed to be able to evaluate this case before the October deadline. They moved it to a later date to accommodate apparently the insured, and the insured didn't show up.
No.
I'm mystified by your brief saying the plaintiff never refused to attend a medical examination. She didn't show up on September 12th.
But State Farm was previously advised that she was not available on that date, I believe.
On the 5th.
On the 5th and also on the 12th, as I recall. And then we did ask for certain conditions to be imposed, including some things that State Farm did agree to.
Okay, I've missed the part in the briefs and in the record where the 12th was a bad day, and that was some reason why she didn't attend. I thought that they ultimately agreed to Dr. Mauricio. They agreed to go to Orlando, although they initially raised questions, and they had a problem with September 5th, but then the date was changed to the 12th, and that was all agreed to as far as being in Orlando with that doctor and the 12th, but there were these additional conditions.
my memory, and I know Ms. Russo will correct me, I believe there was a suggestion that the 12th was not a date.
Well, I may have overlooked it.
And it's not just an issue, Judge Rouse, of if you don't show up when you ask for certain accommodations, some things of which were clearly addressed in the policy, and that is the request for a report. The State Farm policy specifically provides that the examiner is, upon written request from the insured, is to give them a copy of the report. We asked for that up front.
Thank you, counsel. Your time has well expired.
Thank you.
Just briefly, Judge Rouse, you are correct. The 12th was agreed upon, as was the doctor and the location, but the insured decided to file suit on the 10th, so she just never went to the examination.
Do you acknowledge that you could have filed a motion to dismiss based on failure to comply with this condition preceding? You could have, couldn't you?
We could have, or well, they should have just not filed the lawsuit. They shouldn't have filed the lawsuit.
Yeah, but they did. And so what do you do, and what is your remedy in the event that they file a lawsuit without meeting all the conditions preceding? You could have inserted it as an affirmative defense, as you did, and you also could have moved to dismiss the lawsuit because the lawsuit wasn't appropriate because the condition preceding the filing the suit hadn't been met. You didn't do that, did you?
What we did was we looked to the governing law at the time, which was De Ferrari, as adopted by this court in Cazuras, which said if you don't comply with the condition preceding of submitting to an independent medical examination, then just as the policy says, you're not going to be entitled to any benefits, and you get and the insurer is entitled to summary judgment. So we moved for summary judgment.
Okay, so it's a condition preceding to benefits, to having benefits under the policy as opposed to filing a suit.
Well, they can't bring an action against us, and they have to comply with the conditions precedent in order for us to know what benefits are owed. The courts will never have anything to do with it. But just briefly on the suit, the bringing a deck action, what our policy provides is there's no right of action against us under the policy, meaning for policy benefits. But of course, the law affords all parties the rights to bring a deck action.
I don't buy that argument that applies to deck actions to determine coverage or determine what a policy means and whether this is reasonable under the policy, whether that's reasonable, and you know, having the court declare, okay, well, this should be reasonable and this shouldn't. I don't buy that argument, but you know, I am kind of troubled by the fact that you could have moved to dismiss the lawsuit and you didn't, and but whether that's relevant to whether this condition preceding constitutes a breach that deprives them of recovery is maybe a different thing. So we'll have to go back.
I'm not sure that we would have avoided the conundrum given the plaintiff's positions on the examination. I think the crux of the case is that the provision says you'll be examined by physicians chosen and paid by us as often as we may reasonably require, and the plaintiff responds, I'm not going to go to even one unless you agree that you won't do it as often, that I don't have to do it as often as you reasonably require.
It seems to me the bottom line is, and the ultimate issue is, do we say that there's a reasonableness requirement that's essentially tacked on to the, you know, to the condition preceding, or do we just look at the clause and say that's it? You know, the only reasonableness issue is whether, you know, you can ask for more than one. The policy provisions are clear. They had no right, therefore, to tack on these extra conditions. So it seems to me the ultimate issue is, do we look at the policy? Is it clear? Is it unambiguous? And the only reasonableness issue is the number of exams, or do we tack on to your policy and every other policy reasonableness issues as concerning, you know, their request for conditions for the examination, and then the trial court has to look at that based on a reasonableness basis. So it seems to me that's the ultimate issue here,
And
at least to me.
So you're glad you withdrew that reasonableness concession?
thank you. We would ask for a reversal.
Good and bad faith, I think. All right.